Okay, I think we are live.
Yep.
Hi, everybody. Thank you for joining us here at Academia Express for another episode of our podcast dealing with issues of immigration, immigration law, immigration practice. I would like to welcome Mr. Vatsa Modi from Modi Law. Mr. Vatsa is one of our associates. We work with him on various cases, and he'll be part of our team in the future as well. And I would like to open the floor to Vatsa. Maybe you can introduce yourself and tell us a little bit about you, maybe your work.
Yeah, for sure. So, hello everyone. As Daniel mentioned, that I will be working on various immigration matters with him and his team in the future. My firm, Modi Law, strictly deals with immigration matters for now, and we help with any sort of complicated matters. That's what we try to specialize in, and that could include personal or business immigration or any sort of refusals that anyone has faced, and we can bring their matter to court, unlike other sort of services that are out there. Yeah.
Mm-hmm. So it's interesting. Vatsa, you said particularly cases that are a little bit more complicated or involve the court in in whatever way. Sometimes clients are confused. Like, what are some cases that you take to the court and whatnot? So let's start with this. So based on your experience, for example, what are some of the typical cases that go to court mostly?
Well, I would say it could be anything. It could be personal or business immigration, study permits, work permits, even visitor visas can go to court. But it's usually those cases where, you've done some of these immigration applications, and if they're almost like a sure shot application, the client meets all the requirements and they still get rejected, for those cases, like there's no other way, because when you reapply, their factors, all their credentials and everything are going to still stay the same, right? You can't reapply in any other way. Maybe your submission letter could be better, but that's the only other thing, right? So for those matters, I take them to court saying, hey, we take it to the federal court of Canada, and we tell them that, this is the client, these are the requirements for this application, and we submitted all these documents that met all these requirements. So please reconsider this application. The immigration officer who was in charge of reviewing this applicant's file has made an error, and their reasons for refusal are quite generic.
Sure.
So it needs to be reconsidered, and
Understood.
that whole process is known as judicial review.
Judicial review.
Yeah.
So let me get this straight. As a lawyer, what's up? Okay. As a lawyer, there are, for example, you are part of what upper society of
Law Society of Ontario. Yeah, now it's called Law Society of Ontario. It was
Law Society of Ontario.
Yeah, it was Upper Canada a few years ago.
Okay, so what are some of let's say privileges that you get as being a member of this society, and what are some of the things you do? For example, things that not other people can do, as you need to have a law degree and you're a lawyer.
Right. So anything related to court.
Okay.
Basically, like if the matter needs to go to court, I'm the only one. Like, lawyers are the only ones.
Right.
People that are licensed from these law societies of different provinces, whether it could be anywhere, because the federal court, all it takes is that you're licensed by the LSO or any other law society. And the other matters are, sometimes, some of these applications require certification of authentication or notarization. I need to, make sure that affidavits are commissioned. I'm not sure there are notaries out there, but then I can also do that based on my credentials.
Fair enough. So this essentially gives you the privilege to stand up or represent clients in front of the federal court or the provincial court as well.
Yes, any court. I can go to the Supreme Court with the judicial reviews. If usually go ahead.
can you explain this? Because a lot of people ask us, well, what are some of the courts we have to go to? Like in case, for example, if our case gets rejected, what is the court that we need to go to? And as you know, Canada has this federal system. There's layers of jurisdiction, right?
Yes.
Can you explain a little bit the difference between the Supreme Court, federal court, provincial court, municipal court, and whatnot?
So immigration falls under the federal jurisdiction, correct?
I understand. Okay. All federal cases, all immigration cases fall under the federal.
Yeah. So anytime you're doing a judicial review, you're going to the federal court. It doesn't matter if it's study permit, work permit, business immigration.
Provincial nominee program.
It doesn't matter. You're going to the federal court for that.
Yeah.
And when you go to the federal court, usually the matter, like in judicial review, like they try to opt for settlements where it's like, okay, yeah, we see that there's an issue with this when this application was first reviewed by the immigration officer. So, we're just going to settle the matter. You can go for reconsideration, and usually that's enough and there isn't anything more. But once in a while that, some of these questions may be, unanswerable, or like, like if the Federal Court of Appeal deems that there's a serious question of general importance involved in the matter, then they will grant leave for appeal in the Federal Court of Appeal. Let's say if the judicial review is unsuccessful in the federal court, then you can go to the Federal Court of Appeal with that question. But I haven't been to the Federal Court of Appeal yet because, usually the matters do resolve through settlement. Through settlement, not even through a hearing.
Settlement.
Yeah, through a settlement. Usually with my application record and my written submissions, it's taken care of from that point onwards. And just the correspondence with the respondents, which are basically like the Ministry of Citizenship and Immigration.
Right. So now we're talking about cases, for instance, everything seemed to, for example, the client followed the requirements and regulations closely. But then for whatever reason, it was rejected, right? And now, then in those cases, we have this capability to take these cases to the federal court and to try to, settle the matter through a judicial
review. So what happens when you win in the judicial review, what is happening is basically the court is going to quash like the negative decision, and they're going to order that it is reconsidered by the same immigration department. So let's say, I know a lot of your clients are from Mexico, right? And they've applied in the embassy, the IRCC in Mexico, right?
Correct.
Then they'll go back to that embassy, the IRCC department in Mexico, and they'll have to review it over there again and reconsider it. And there will be a note on their record that this has been to judicial review.
I understand. And so let's say, in other words, they sent the case back to the same officer.
Not the same officer, same department. Hopefully it's a different officer.
Okay. So the same department to get basically a second opinion or another.
A second. Yeah, exactly. And at that time, when that happens, especially with settlements, they kind of give you a little bit of they'll give you like an email address, like of that place, whichever embassy, whichever place that it's sent to, the processing center, and you can send them any additional documents or any additional updates since the application was first submitted till it's been a year or two by then, right? So if they want to send any additional updates since that time has passed.
Okay, that's interesting. And then say the case goes back for the second opinion at the same office. Yeah. Is there a chance for the case to get rejected again?
There is. There is, but
so it's not guaranteed that they're going to.
No, well, nothing is guaranteed in the Canadian immigration, right?
That's true. That's true.
So nothing is guaranteed there, but yeah, usually what happens is Canadian immigration saw that there was something missing in the application. And when they allow us to reconsider it, they also give us an opportunity to send in any additional documents. And at that point, hopefully those additional documents and the updates really kind of resolve any doubts that they may have. And hopefully their application does get approved at that point.
Okay. So
Yeah.
that's interesting. So for instance, say that person sends their application and it was denied, okay? And let's say there was some missing information. When we appeal this process, they give the client another opportunity to add those additional information.
So usually, like when a case comes to me, anything like that, what I try to do is if the application in the first time was complete, they met all the requirements, then I would suggest judicial review. If not, I would suggest to just reapply. If you know for sure that, okay, this was actually missing, then might as well reapply, because then it may just go through based on that.
It
For
might
example,
be easier, in other words.
yeah,
to
it
just
may be
reapply.
much easier. We don't want to waste the court's time. We don't want to use up any judicial resources that could be used elsewhere. So that's the main reason for that. Especially right now I have a client that may be interested in a JR, but when I looked at his files, it was for a work permit for his wife. There was genuinely like documents that were missing.
Right. Right.
So, and he was convinced that he needed to do a JR.
Judicial review. Right.
Yeah, a judicial review. And I had to convince him to not do that instead of, because, let's just reapply, because I think that will sort the matter out even quicker than doing a JR. But JR is for the people that are like, the application was nearly perfect, and then there was an error. Like, what happened? It needs to be reconsidered.
Yeah. Right. And there is a real chance that is there a real chance that the officers could have mistaken an issue on the case, and so it might be grounds to appeal the decision, or no? Is it, in other words, when a case gets appealed and you get a positive decision for reconsideration, right? Send the document back. Is it usually because the officer made a mistake or things were missing?
So usually it's like, it could be a mistake, or it's just like, the reasons for refusal are quite generic.
Are vague, okay.
Are very vague, and there's no opportunity to argue those vague decisions.
I understand.
Or sorry, reasons, not decisions, vague reasons. And the reasons are very generic, like there's like I'll tell you, like there's a few, I think in my notes I was preparing for this, like there's a few that are just, like, for example, won't leave Canada. That's a very common one, especially with the temporary, permits, study permits, work permits, visitor visas. It's like the person won't leave Canada.
Okay, so these are some of the reasons for case rejections that might be grounds for appeal.
Yes. No. Yeah. I mean, like at the end of the day, those are rejection reasons at any point, whether it's a good application or a bad application. These are usually the breakdowns of reasons, and I would say that's like the most common one, especially with the temporary applications, because it's a temporary application. They want to make sure that you're actually going to go back to your country of origin afterwards.
That's right.
Right. So that's the main one, I would say. And then depending on the type of temporary application that you're doing, let's say you're doing a TRV, then they want to see that there's a purpose to your visit. They want to see what, like, let's say you have a family event in Canada and it's a wedding or something in Canada and you want to come to attend that, you need to provide reasons for that, proper reasons. Why are you coming to Canada? And then there's also people that just genuinely want to travel in Canada, right? Then provide a nice trip itinerary, like a good, what's your plan? Like, oh, you want to go to, like, you want to land in Toronto, you're going to do a road trip to, like, whatever, Calgary, and then you're gonna make your way to Vancouver, then you're gonna fly back to your country. Like, provide a detailed itinerary of that.
That's right. So like your reasons to want to visit Canada.
Yeah. Exactly. And then like the other one, the most common one, like is study permits.
Okay.
Like, so study permits also, the one of the main reasons is that they won't leave Canada given, for example, the employment prospects back
Right.
home.
Right.
Like if you're doing a program that's kind of irrelevant to your prior study, your education or your work experience, then they'll question that. Like, why is that your study plan?
Yes.
You
I
know,
understand.
like a person who's a lawyer in a country wants to come here and like study like science,
That's right.
right? It doesn't make any sense.
In other words, if I get it, like, you have to establish your genuine,
Yeah.
that you have genuine intentions in what you're applying for.
Oh, 100%. 100%. If it's not genuine, then even a JR can't do anything,
Oh, okay.
It needs to be genuine. You need to be honest and truthful with everything that you're providing to Canadian immigration. You don't want to lie,
Yes.
because, or like be even like not even lie. Like lie is a more of it's a stronger term, but like, don't lack the genuineness in your application, because the more genuine it is, the more likely it'll be approved.
I understand. Now, I have lot of people who are concerned. They say, their visa got rejected, right? Is a rejection on a client's case necessarily a bad thing in their future applications?
um I don't really know how to answer that, but
Mhm.
they will see it when you reapply at some
But
point.
it might depend, correct? It all
it,
depends.
it, it will depend, depending on the type of program, depending on your profile, like the client's profile as well, because it's kind of hard to say. There are people with rejections, one rejection, who have been successful in their second attempt, right? But then there's people that after the first rejection, they try again, and then they get a second rejection on their record, which is obviously not a good thing.
Yeah.
And a lot of times these clients, what they do is either they go to these unregistered consultants, immigration consultants, or
Right.
like they won't go to a lawyer,
Right.
and they want to save costs, so they'll either try to do it by themselves, or they're
Right.
going to go to these unregistered consultants
That's right.
that are just out there spewing like false information.
And this is called false representation, correct?
It's misrepresentation.
Misrepresentation.
Yes,
So if you have an
misrepresentation. That's if
issue
they're
with
lying.
if you have an issue with misrepresentation, like things like major
That's a
rejection
bad.
cases, that could be
Yeah, that's
bad for your.
that's bad. That's bad.
And
You could potentially be banned
so, in
from
other words, let me
applying.
just to clarify for our audience, a case of misrepresentation is if you lied about something,
Yes.
about yourself or your profile, and
Yes.
that could be a really bad, I guess, negative tick on your file, correct?
Yes. Yes.
I,
Very big negative tick, and it could potentially ban you for. They say like Canadian. They say 5 years.
oh wow,
A ban for 5 years. You can't even apply. But usually, like when those bans are on your record, that's not a good sign for even after the 5 years.
if
So
you get
you,
banned from by the Canadian
yeah,
government.
yeah. So you want to avoid that at all costs. Like, because all these forms, any of these immigration forms, they give you the opportunity to tell Canadian immigration about your immigration history, whether it's with Canada or any other,
That's right.
countries, right?
That's
So
right.
might as well give them that information.
You have to be truthful about anything
100%,
you give to the. Yeah, exactly.
100%, 100%.
You can't lie or try to misrepresent a document or a file or information about your
No,
intentions.
no, not at all. It's not worth it for a few $100, few $1,000. If
That's right.
if your dream is to actually come and live and reside in Canada for your future and your kids' future, you can't risk that for
That's
like
a
a
good
few
point.
$100, few $1,000, right?
That's a good point.
Yeah.
Now, uh, let's talk about something called deportation.
Sure.
when would you be deported? What does that mean essentially?
Like from Canada?
Yeah, so a lot of people say, they ask us, okay, what does it mean to be deported? What does deportation mean under immigration law, essentially? When a person gets deported, what does that mean?
So they have to, leave the country at that point.
Have to
They
leave the
have
country.
they have to leave the country, and usually it's related to some sort of criminal activity.
Oh, so okay.
Yeah, it's usually related to that. I can't really speak too much about that because my practice does not involve
Deportation.
deportation or criminal matters, like, because
Right.
immigration is it's a big umbrella.
Right.
There's like criminal law involved in there as well. There's family law involved in there too at times.
That's right. That's
So
right.
I kind of avoid that part. So I don't want to provide any wrong information right now to the viewers. So, but bottom line, usually deportation like has some sort of criminal element involved.
That's
But yeah, like I would say uh, it's better to find a criminal lawyer who also specializes in immigration for that.
I understand.
Yeah.
Can a deportation, I know you said you don't want to talk much about, but can a deportation be appealed?
So there's like few different categories of deportation orders. There's a removal order, and for that you could apply for a stay of removal, which kind of pauses that order until the processing happens. And in that time, it's very common that someone, like, while that is being processed, someone will, like the lawyer or the representation, whoever they have, they'll also apply for an H&C case for the person.
Mm-hmm.
And based on the H&C case, it's like, hey, like, we have this matter pending with IRCC.
Yeah.
Can you please hold off on this removal order until the H&C case is resolved? That's a very common scenario. It's one scenario. There's probably plenty others that you can prescribe to these clients.
Right. I understand. Yeah. Now, because we, like I said, we work with a lot of clients from Latin America, and a lot of our clients have applied to the United States. And at some point, one way or another, they might have had a US visa, and some of them might have had a US visa who have been rejected in the United States.
Mm-hmm.
Is there rejection with the US visa? Can that be grounds for a visa rejection in Canada?
Once again, it depends on what it was for. At the end of the day, Canada and US do share information with one another, immigration's related information. And it depends on the reason, because, if it's something like, once again, if it's something like misrepresentation, they take that very seriously.
Even if it's for, like, say, misrepresentation, even in the case of the United States.
Yeah, because at the end, like, they'll see that rejection, right? For that reason. Right. And it's not it'll be tough for them to come to Canada at that point, especially because US and Canada are very, like, tight in the way they deal with immigration matters between the two countries.
I understand.
But like, not to say that, like, if they were like just a regular flat out rejection, like, for example, my very close family friend of mine, he has been rejected from the US just for whatever reason. No criminality issue, not even a medical issue, just for whatever reason. Yeah. Right. But they have a visitor visa for Canada.
Oh, so they got the visitor visa for Canada.
Yeah, they do have that.
So, in other words, generally speaking, like you said, it depends. But generally speaking, if the rejection is not due to criminality or misrepresentation, they might still see it, but it might not have a tremendous effect. It might not have a total effect.
No. As long as, because look, at the end of the day, they do, of course, they look at the history, the immigration history of the client.
That's right.
But at the same time, like, if they sort of meet the requirements that are prescribed by IRCC for whatever it is, study permit, work permit, visitor visa, if they meet those requirements, then I don't see why not. Why would they be rejected again? Like I said, my personal, like very close
That's right.
family friend of mine has had that experience where they have been rejected and they still haven't been to the States yet, but they come to Canada every summer.
I understand. That's thank you. Thanks for that clarification.
Yeah.
And you know, we're drawing to the end of this our discussion. I know you have work to do as well.
Yes.
Other clients to attend to. We have cases, for instance, people apply. Some of our clients, they apply and they seem to meet all of the requirements. You know, they've met all of the requirements and they've sent all their documents in. But for whatever reason, the officer just rejected their visa, right?
Yeah.
And then they requested for the ATIP, and the ATIP is this application for access to information, essentially. And the information comes back, and we can't really find any, let's say, convincing reason for why that visa was rejected. Can you would you be able to work with these clients to take these cases to the federal court for judicial appeal?
That is the perfect client for the JR.
That
is literally the most perfect client for a JR. The ATIP notes are one thing. They're quite extensive, and you could probably find the reasons, like the notes for reasons in there. But then when I actually start the appeal process with the federal court, then the federal court registry makes a request on behalf of like our file, and that provides us with more whatever reasons they have for refusal, or if they don't have any more, then they'll give us a notice saying that they don't have any more reasons. And then, especially like you said, if you've done everything and the ATIP doesn't show any like valid reason for refusal, then that's a really good candidate for a JR.
Excellent. And how long does it usually take to appeal a case?
So, you know, it could be as short as 3 to 4 months, or it could be as up to long as, I would say it can go up to a year.
Okay, yeah. 3 to 4 months to up to a year.
Yeah, because as I mentioned, that a lot of them are settled prior to hearing, or even if a hearing is scheduled, then there may be a settlement before the hearing actually takes place. So because of that, it could be as quick as 3 to 4 months, and you know, as long as a year.
Lovely. Yeah. And you know, in I guess in wrapping up, do you have any general recommendation for people who are interested to immigrate to Canada, or who are in Canada, or or are, you know, in the process of the immigration application?
Number one, I would say is be truthful in anything that you do in this, because you do not want anything negative on your record. That record needs to be very clean. And then the second thing is, you know, if you're young, go for a study permit. If you're qualified, go for a work permit. And if you have the capacity to invest, then go for business immigration, right?
Wonderful. Well, thank you so much. Thank you so much, Mr. Vatsa. Once again, this is Mr. Vatsa, who works with us at Academia Express with and his company Modi Law. I invite you all to connect with us, communicate with Mr. Vatsa. We'll put the information below. Just feel free to click on the link, and we'll be happy to work with you. If, for instance, your case has been rejected, you think there is reasons or the reasons for appeal, we'll be happy to look over it. We'll pass it on to Mr. Vatsa. He'll be able to provide you with professional opinion. But any final words?
No, thank you for having me, Daniel, and hopefully we can work together with the viewers that are watching this, right?
Absolutely. Thank you, everybody. Bueno, muchas gracias, hermanos, amigos. Estamos en comunicación siempre. Y Mori, hasta luego.
Thank you. Take care.
Bye-bye.